Talk Shoes.
Recorded live.
Hi, everybody. It's June the 25th, 2015, and it's time for my private audio call. Tonight, our special guest speaker, back by popular demand, is Daniel Benham. Good evening, Daniel.
How are you doing tonight?
I'm fine, thank you. I hope everything's going good for you.
Yeah, it's not too bad. I've been on listening to your little conversation there for about 5 minutes, and seems like Carl has quite a few people that his tactfulness just kind of rubs the wrong way. I think the guy's very brilliant, but sometimes he's got a tactful way of presenting it. So.
Right, he's adamant about what he knows, and it's like nobody else can have a method or a process, you know. But God bless him, you know. What are you going to do?
Well, I've met many people like that, so God bless him for trying. But anyways, Ange, I apologize. I'm kind of in the down spirits today. I had a funeral for a very good friend of mine who was killed late last week in a motorcycle accident. He was stopped at a stoplight, and some young kid, I think, was texting or something, and drove the van right over him. So.
Oh my gosh, that's awful.
Yeah,
well, I'm sorry to hear that.
Yep. So if my mood doesn't sound very good, folks, I apologize. That's what it's for. But I'm going to do the best I can tonight. I have absolutely no idea what I'm going to talk about tonight. So I was going to kind of throw it out there and let your popular demand comment there soak in with the listeners, and let them go ahead and just shoot away, and we'll just do a free-for-all answers and questions, and if it leads off into something else, so be it.
Okay, well, I think a lot of people are interested in the foreclosure, your briefs. People want your brief. People email me for that a lot, and I do that. I don't have them. I guess I don't have the both of them up on the internet. I have one, I believe, but I have to go through and check again. But if anybody,
you're talking about the affidavit or the briefs that were done in court?
The briefs, the affidavit I have up there, and the response, but the briefs I don't have up there because they're big. If somebody wants them, they can email me for them.
Okay.
If anybody has a question for Dan, please press *8. I hope there's a lot of people on the call that have emailed. People have emailed me wanting to know when you're going to be on again, and asking me to forward emails to you. As you know, I do. And I told them all that you would be on tonight so they could ask you their questions in person. So if you guys are on the call, press *8 and you can ask them your questions. Otherwise, let's see here. I'm looking at the chat.
There are some updates with the SEC website that I can go over with some people.
Okay, why don't you do that?
I have a little. I had a little bit of time to go through that. With working 80+ hours a week, it's been a little bit rough on getting anything personal done. But what I have recognized is that back in 2001, 2002, when I first stumbled across the SEC filings, they were actually very simply just called the 424B4 prospectus form. And now I understand that the website is completely revamped. Maybe they just wanted to modify it and update it, but what has happened was they changed the form to a 424B5. That is the prospectus form. And interestingly enough, everything that I have previously attacked in that form has been reworded. And I would like to talk about that for a minute, because they can call it a tomato or a tomato, but it's still the same thing. Prior filings, prospectus filings, required the filer, which would be the lender in this case, they had to post the ownership of the company as well as the notes, or in this case it would be the mortgage securities, which are normally put into a pool or a big bond, so to speak. And what has happened is they've changed the language. What used to be, XYZ bank has no right, title, or interest, in any of the notes that it holds for its consumers. Now everything has changed to what they call beneficial interest. It says that the beneficial interest owners, or the owner of the beneficial interest of the trustee or the assets. So it really does not say there is an owner or there is not an owner. They are speaking now only about the beneficial interest in the trust. Well, easily said, the affidavit still will be effective because we go through and explain that there was never a trust disclosed. If somebody puts you into a trust and they don't disclose it, I'm sorry, but that is just point blank misuse of trust. There cannot be one. In the law, it's called an unconscionable trust. I can't take property and give it to you, Angela, as being a trustee and have it go to a beneficiary if I don't know it. That would be the same thing as you taking my house, putting it into a trust, and then letting other parties benefit from it. I didn't know about it, and I'm the grantor, and if I didn't know about it, then the property doesn't go in there. Hence, there is no trust. So when they talk about beneficial interest in the trust, they have a beneficial interest in nothing. It still doesn't change. Just because they don't specifically state that they don't have any right, title, or interest, like they used to, made it crystal clear, it appears to me as though they are trying to hide the best they can using Johnny Cochran verbiage that now it is a beneficial interest. It sounds warm and fuzzy. It sounds nice and professional, and it sounds like it's airtight in the legal world. However, a beneficial interest is not an ownership interest. So there still is no ownership interest listed anywhere. So therefore, if there was no trust created, how can there be any interest, whether it's ownership or beneficial interest, in something that doesn't exist? I hope that clarifies and lets people know of some of the updates. So when they go to the SEC and pull down this prospectus form, they read that and now understand exactly what's being said and that it does not change anything with regards to the affidavit.
Wow. Okay. There's a question here on the board. Let me see here. Would you share with us about how you got rid of your IRS tax liens?
No, I will not.
Just you answered that.
I can't do that right now, folks. I still have 18 months of federal paper. Please do not put that kind of burden and responsibility on top of me.
Okay.
It will come out in the book, though. I will clarify that very, very clearly in the book that I'm writing. It's an autobiography, and I am probably a little past half done with it.
Oh, wow, that's great. Any projections on when you might be done with it?
I am hoping 90 to 120 days.
Oh, wow. Well, please let me know.
Right, and I'm also working right now with certain people in regards to the possibility of making an actual video documentary and making them both go on social media very fast, very hard in media format, so that way it spreads fast, hard, and all around.
Fantastic. Well, I look forward to that, and I'll do everything I can to help you get that viral.
Yep, thank you. Thank you.
You're welcome. All right. Well, you know what? No one has their hand up at the moment. Does anybody have? Oh, yeah, there's one. North and Central Kentucky. Go ahead. You've been unmuted.
Hello, can you hear me?
Yes, we can.
Hello, Angela. Thanks for your talk show. It's been very helpful.
Well, thank you.
Assume this is Dan Benham on the line?
Yes, it is.
Yes, it is. How are you?
I'm fine, Dan. Thanks for your videos. I emailed Angela about some mortgage problems that I'm having, and she said the best guy that she knows of is you, and I was just amazed about what I heard out of your mouth on those videos.
Mm-hmm. They've been drastically updated since then, but yeah, it's good information.
Well, I got mortgage to a hometown lender, and I asked them at the time, because I had already read up previously on mortgages, where is this going to be kept? Is all the paperwork going to be kept here? And the loan officer at that time said, yeah, we keep everything in-house. I said, okay, all right. I didn't know any more than that to ask, really. I'm ignorant of the whole thing.
Mm-hmm.
And but now I'm going into what the lawyer wrote in his letter as a pre-foreclosure stage. And basically what they said was if they didn't receive any letter from me or communicate from me asking to validate the debt, then after 30 days they would just assume that the bank was telling them the truth, that the debt actually existed.
Mm-hmm.
And so that's where I'm at right now, is trying to figure out the best way to proceed. I did send them a letter saying basically what I've heard from Angela's favorite phrase, prove it.
That's a good one.
And I'm just waiting to hear back. I put in my letter to, I required them to respond in 7 days from receiving my letter. So we'll see what happens.
Mm-hmm.
But I don't know,
Okay.
I don't know the ins and outs of it like you do. And I just, I'm looking for any insight to try to figure out the best route to take.
Okay. Well, I'm assuming that you pretty much understand what all transpired and what they did that they didn't tell you and so on and so forth.
Well, I agree.
But,
that's the best thing you said is what I know in my heart is that they didn't fully disclose every damn piece of stuff that they put in front of me as to
right.
what was really going on.
Right. Oh, no, they can't. If they were to tell you that this is a trust and we're putting the asset into a trust and we're being the trustee and we're going to sell it on the open market, and the beneficiary is going to be the new person, everyone in this country would understand completely what just transpired. And if they basically just took the money out of your pocket and funded a loan, took it, used it for their own financial gains, repeatedly over and over and over again at your expense, and if you don't pay them back for what they stole from you, then they take the property as well. It's really that simple. It in a legal way, in the forms that they use, and the way that they present it, and the way they package it and sell it, and go through all the legalese to it, it's not that simple. But in layman's terms, that's exactly what just transpired. However, once again, how can a trust be formed without a grantor?
Okay.
If the grantor is the person whose asset goes into trust or property, same thing. So if there is no grantor, or the grantor was deceived into putting his property in trust by the very trustee who never really was appointed, right? Exactly. There is no lawful trust. It's deception, it's negligence, it's all kinds of stuff. In trust law, the word disloyalty of a trustee is a big one because they have to be loyal to one person. The only real responsibility of the trustee, there's actually two of them, but one's more important than the other. The first is the protection of the property or asset that's put in trust. The second is to fulfill the grantor's wishes. Now, on paper, they make that sound good. I want money? Great. I'll be your trustee. I'll take your money, and I'll put it in the right spots. However, they did not tell you and disclose to you that this was all one great big trust and that you were the grantor. That right there is the entire foundation of this entire problem in this country. If the country and the people in this country knew that and everybody knew it, we wouldn't have this problem.
So basically, all I have to make the statement to them is ask them a question or say, I don't believe you fully disclosed all aspects of the transaction.
Well, it's one thing to do the Bubba Said approach, because now when you want to challenge something, it's not the hearsay thing. It has to be in writing. If you don't put it in writing, it's considered hearsay in the court of law.
Oh, I'm going to put it in writing.
That is exactly why that affidavit gets put together. It's obviously got to be critiqued to your specific case. it's a boilerplate. It needs a little help. You have to go through there and explain what transpired and who you sat down with, and go through and tell them exactly what happened and be honest with everything. And if that director,
I know what you're talking about now. I did read that was on your site on Angela Talk to on her website, right? There was a page there of yours. Yeah. Okay. I did peruse that. Yes.
right? If that affidavit is sent to one of the directors of that lending institution, the original lending institution, they have to rebut it, or it can be used to rebut or debunk any claim they have from that day forward.
Well, I thought the one that's making the first complaint is the one that has to prove their allegations.
You're talking about a brief. I'm talking about an affidavit that could just get certified right straight to the directors of the lending institution.
Okay.
That's the foundation of this whole thing. We're not talking court documents yet. If I have a mortgage, and I know that something was wrong with it, I'm going to go to the director, solely the director of that institution, because under the original Bank Act, and even to this day, the United States Code, the original statutes, and the original Bank Act itself state that the director is fully liable and responsible for every person that is engaged in his business. So that is why it goes to the directors, because if the directors know...
I have been sending letters to the CEO, and you were correct in your video that there are 5 board members.
Oh, absolutely.
At this bank, and the CEO is one, and I've been talking with him since day one, basically.
Yep. I would certify mail that affidavit right straight to him if I was in your shoes. And you got 30 days to rebut that, and if you don't rebut it, guess what? This whole issue is gone. And then wait. If you don't have to wait. Do what you want to do, but you could counter sue them for damages for anything that you've been damaged since this has happened, or you can actually just sit back and wait for them. And if they try to sue you, file that right in court with a complaint. They're going to file a complaint, and you're going to file an answer to that complaint. And I would actually use what is commonly called a counter complaint. And when they make an allegation, I counter-complaint and just say, see attached affidavit. You've already answered this. You can't now back out of what you've already had an opportunity to answer.
Okay. All right.
So.
All right. I just found it strange that they said that they kept everything in-house, and what I've been reading and what I've been reading.
Well, under Truth in Lending, they have to keep it for 7 years. Even the original mortgage company, which is nothing more than just a mere broker, a servicer, they have to keep that stuff in-house for 7 years for audit reasons. Not the original, just at least a copy.
I thought they sold the note. Oh, yeah, you're talking copy. They don't have the original. They have a copy.
Right. No, the original note is, unless they've changed this, and this came from a specific Federal Reserve employee when it was told to me. The original note goes to the bank, then it goes to its holding company. There's a holding company that basically holds a bunch of banks from that area, and it's basically the Trilateral Commission. You got a whole bunch of banks, all belong to one holding company. That holding company, along with others, are part of a Federal Reserve Bank district. Those Federal Reserve Bank districts are all part of the Federal Reserve. It goes up from there, but I'm not going to get into that in this call. But basically, that's the way that all happens.
Okay.
And he flat out told me that the note goes from the bank to the holding company to the Federal Reserve District to the Federal Reserve and gets shredded.
Well, the other thing I was thinking of, and please be blunt in your response, is, you know what, I don't want everybody else to think this is me being too ignorant, but they gave me 60% of the appraised value of. I had a separate appraisal done, and basically they're trying to steal the house for, like you say, the money that the credit that they gave me, which is me, and if they just gave me the other 40% of what they agreed to, I would probably walk away and just forget about the whole damn thing.
Right. And I'm not going to argue that. I'm not going to call you ignorant. Everybody has their own decisions in life and also their own roads to take. However, the way I look at that is I didn't want any of it because this is a major national crisis. People don't call it that. I do.
Okay.
Ever since the Federal Reserve was created, we've had market crashes. We've had Black Fridays or Black Mondays, whatever you want to call it. People's money's been stolen every 10 years or so. The market takes a big dip and people lose. They've had houses confiscated. We've had citizens shoot themselves and kill themselves because of it, because they can't handle losing their house and they don't know what they're going to do. We've had people go out and become thieves and steal other stuff from other people. I mean, this is a bloodbath that these people have created, and they can go back to being honest the way they were before 1913 if the people would stand up and say, you know what, no more. I don't care. So did you have
a mortgage that you dealt with on this issue?
I did it on my own first.
Okay, I got you.
I was my own first. I would never suggest this to somebody else unless I did it first myself.
No. I wasn't accusing you of that. I didn't know, and I didn't hear in your videos. You know.
Right.
You say
that house. And if anybody wants to do any records on it, it was 249 Peachtree Lane, Traverse City, Michigan, 49684. 686. I apologize. And that was the house that was done. And Daniel Mudd was the director of GMAC. I was working for a General Motors dealership at the time. I was director of finance for 13 franchises up there. And when I uncovered this, I said, wait a minute, I'm going to check this out. So I did like you, and I started writing. And GMAC's owner or CEO at the time, director, he deferred everything and said, you're right, we don't own it. Fannie Mae owns it. So then I wrote to the director of Fannie Mae, and I asked them exactly where their receipt was to show proof that they paid for it. And I didn't get any response from them. So that's when I started to craft up what is now called the affidavit, and I sent that out. And it was probably within 30 and maybe 45 days after they had received it, because I did do it certified mail. I was never charged another payment, nor taxes, nor insurance, or anything. And my credit report went to paid off, 0, paid in full, paid as agreed.
Cool.
And that wasn't even 2 years into a 30-year mortgage.
Wow.
And when that happened, that's when I went public. I said, oh my God, I just cracked into something here.
Were you in foreclosure at that point, or just were you still making payments?
No, I was still making payments because I wasn't into. I mean, I'm taking you back to 2001 now. This is back when all this stuff first started even being discussed out there, and I was still current and everything. And I said, well, why not just give it a shot? And I always encourage people to this day: do not stop. Don't stop making the payments. And that's just my personal opinion. And I say that because if you stop, then that gives them a reason to start charging you in court or starting a foreclosure process. If you can continue to even make part of the payment, if you go into court, just say, hey, I could only come up with $300 this month. I didn't have any. I don't have that money. I lost a job or whatever it was.
I tried that. I did that, and had my checks returned and said we will not accept them.
Wow.
There was another guy that was making his payments into an escrow account. And he won his foreclosure. Also, it was in the appeals court, but he was making the payments and he was putting them in an escrow account. But I guess either way.
All right. Well, Angela, I appreciate it. Dan, thank you so much. I'll get off the call now.
Thank you.
You're welcome. Yep,
good luck to you with your issue there, your foreclosure. I hope send him that affidavit.
I will. Thank you.
All righty. Next up, Donaldson. Go ahead. You've been unmuted. Did you have a question? Donaldson.
I'm here. Sorry about that.
There you are.
Yeah.
Okay.
Thanks for bringing me on.
Sure.
My question is about settler. And if we're the grantor unknowingly, unwittingly, then would the
you know what I'm getting? We're getting feedback. Do you have, desk speakers on or something?
Hold on a second.
You want a speakerphone?
Thank you.
Yeah.
Okay.
Okay.
Is that better?
Yes.
Okay. Basically, I was wondering about the court that assumes jurisdiction over the trust. Would they be the settlor then? And then wouldn't they have a duty to actually perform to protect the trust?
Please don't take this wrong, but what trust?
Exactly. I get what you mean. Exactly. But isn't there a presumption of one about,
That's what the affidavit does, is it exposes it.
Okay.
I mean, what trust? How can the court be granted jurisdiction to settle a trust that doesn't exist? That's what I was saying. When someone files a complaint, use that affidavit to rebut everything, standing, jurisdiction, all of it. I don't know what you people are talking about. There is
I think you're talking about inter vivos trusts, though. There's this present declaration thing. A trust can be created either by a person declaring himself trustee for another or by the transfer of property to another as trustee.
Mm-hmm. Right? So when did you transfer that property knowingly into a trust?
Exactly. I didn't knowingly, but since there's this presumption.
So
You said your affidavit.
You're going right after an unconscionable trust again. It falls right back to what trust. I'm
Right.
trying not to be facetious, but they are going to try everything they can to presume. And you have to stand there and say, there was no trust. I had no idea any of this was going on. Matter of fact, if the bank wants to sit there and try to even say that there is a trust, which they will not do, one of the main documents, I've said this over and over in prior conversations, is that there's one document that everyone signs at mortgage closure. And that form is called the Mortgage Servicer Disclosure Form. And it point blank explains that the bank is nothing but a servicer. And a servicer is not the owner. A servicer is merely the party that takes payment.
I think you're answering my question, which is basically that you're saying, yes, that the court is a settler. Even though there's no trust, what I'm saying to you is that there has to be a settler, and that I think that the court is they're taking on that role, basically. Even though
they're presuming it, correct. Yeah.
Right. Okay, thank you. That's all. I'll be listening. Thanks a lot, man.
Yep.
Okay, thank you. Moving on. Let's see here. Arizona, you've been unmuted. Do you have a question or a comment?
Hello, good evening.
Hi.
I have a few questions about what I was listening to just now, and if a person or if someone, on the terms, wants to get a property to live in, what is the best option if you don't go and sign those papers and get a loan and such?
Well, that there's the discipline. There is no way unless you use their system. That is primarily the reason that I'm trying to break down that system so that they go back to the original organic system. And I mean, it's going to take time. I mean, some people, if that's what you want to do, that's what you're going to have to do. I myself, I'm a renter. I just rent from somebody, and I'm not going to play that game right now. I'm going to continue to work on this and hopefully get Rand Paul up there to audit the Fed and try to get. I mean, he's not our answer. I understand that. I don't need a whole lot of feedback on that one because I know I myself don't agree with everything the guy says, but he's right with at least with the Federal Reserve Bank. And that right there in combination with the IRS, I believe, are those two things get fixed in this country, I believe we're well on track to going right back to where we were happy before.
Okay, so the only way you can live in a property and get a property is to go through that system. And I have another question. I'm not sure if you touch on this type of subject, but a car loan, I heard, is considered as such like a mortgage loan.
A loan is a loan.
Okay. Well,
yep.
I had a car that got repossessed because I lost my job and couldn't pay for it. And I got sued, and I had asked for documents proving that they had the right to collect in the suit, but they went ahead and without me knowing, got a judgment because I had moved and didn't have that information available to me right away. So I want to know what is the best option. I know I can write an affidavit to the judge, but do you put that in private or do you file it with the clerk?
Well, any of the affidavits, they should go to the director of the lending institution. And what the problem here is, the last caller did hit something right on the head when he said, "Who's the settler?" The judge, in his own opinion, believes the documents that he sees from Company A. And there lies another major problem and obstacle in the judicial system, is you ask for documents, and they provided what the judge accepts, even though it's not in accordance with what is required to have standing to give the court jurisdiction over the matter to begin with. That is a big issue, and it's also another very, very good foundational piece in that affidavit. At this point in time, your car's gone. The only recourse that you can even try to go for would be to just sue them. And in order to do that, you are now the plaintiff. And if you're the plaintiff, you have the entire burden to prove what transpired, which is, again, why that affidavit needs to go in. The affidavit goes in, they get 30 days, they don't rebut it, it's now true. Now you file a complaint using that affidavit, claiming damages of XXX dollar amount, any interest you paid, payments you've made, plus the loss of whatever the current value was when they came and took it, plus I'd even try for some kind of punitive and actual damages if there was any on top of, and sue them. That's really the only recourse, that I can see that you'd have on that right now.
But they have gone through and already got a judgment, and they're doing a garnishment on wages and stuff like that already.
Mm-hmm.
So I believe I'm too far in the process to go back and do those actions.
I've had people, not with cars but with houses, several years after the fact, go and do this process and had certain monetary damages stop. I haven't heard of people trying to sue them. I've heard people say they want to sue them, but no one's ever sent me actual documents whether they did and lost or did and won. Anybody does have any, I would be delighted to look at what they've done and what the result was so that I can maybe jump in there and give my 2 cents on what could be done in the future so we can actually start getting our money back. However, that doesn't stop the fact that you and your car is gone, and the affidavit, again, needs to be drafted, sent to the directors, then that can be put into the court to do a brand new hearing. In other words, newly discovered evidence was brought in. This whole thing was a scam. It was a sham. I've been damaged. I didn't have this information at the time. It's newly discovered now, and I want this entire transaction to stop. You stop collecting on me, and in fact, now I'm going to countersue you.
Okay. So you're saying send it to the director of the company.
Director of the lending company.
Okay. Okay. I got it. It makes sense.
Mm-hmm.
But it sounds like it will be a long process as they're taking the money out, and I'm trying to have it stopped as soon as possible.
I mean, you got to give the director at least 30 days to even respond. But while that 30 days is cooking, I would certainly be focused on drafting up my motion to reopen the case, or motion for new discovered evidence, or a motion to vacate the prior judgment, all based upon that affidavit that's not going to get responded to. And if they vacate, then that at least stops the garnishment, and now that gives you room to breathe so that you can file your complaint against them for damages.
Okay. That sounds good. I appreciate that.
Mm-hmm.
Thank you.
Mm-hmm. You're welcome. Thank you. Hopefully things work out well for you.
And Hannah Lady here on the chat is saying, look up your garnishment statutes and exemption requirements.
Yes.
But that said,
I
Go
just
ahead.
have that information. But I was just concerned about the request in the first place from the company wanting to, because I figured if I did an exemption, am I acknowledging that everything that occurred is true? Or if I say, hey, I requested these documents and I never got it.
Well, let me try to answer that the best you can. The advice from the person doing whatever typing there in chat is pretty good information. However, I have, with this affidavit, sorry, there's an airplane going over me right now. With the affidavit, again, all of that stuff was thought of in advance. And there's a thing called the statute of limitations where you normally have X amount of time to dispute something. However, if it is newly discovered, it's always grounds to crack open a case, especially, and I mean there is no way that any counterparty can avoid this fact. If your newly discovered evidence goes towards either standing of the party or jurisdiction of the court or both, there is no defense from them. They have to reopen it. There is no choice. The judge has absolutely zero opinion on that. He must hear that case because if the party didn't have standing, then the whole case was a sham. And if the court didn't have jurisdiction, then the whole case was a sham. That, again, is why I focus on standing. If that party, being the lender, call it a bank, a mortgage company, a car loan company, whatever you want to call it, if they didn't have proper standing because they didn't tell you about a trust, the whole thing is gone. There's no reason to go into anything else. I don't care where the note is. The note is not my focus. My entire focus is, does that party even have the right to stand here in court and tell the court that I owe them anything? If they cannot prove that a trust was created, with your knowledge, the game is over.
I understand that part. I get that part. But the thing about it is I haven't been following recently, so I'm not sure what you're referring to about the trust. I know when you have the deed, it shows who the grantor is and who the beneficiary is.
Give me 5 minutes here. Go ahead and just stay unmuted. I'm going to go through very quickly and explain what transpired. And this applies to any loan. Even a small credit card, when you go through Walmart, this is what's going on. There is a lender. You go into a bank. A bank, cannot loan its own money, period. It can't. And it can't use any of its own notes for any of its banking operations. So we know the bank can't give you their money. We know that the bank can't create a debt instrument of its own and use it. So it has to be yours or someone else's. Well, what they do is they are basically taking the money that back in 1913, prior to 1913, we all had gold and silver, was back in our currency. Well, they took that away and replaced it with Federal Reserve notes that actually were supposedly at first good for you to go in and transfer those Federal Reserve notes, that paper money, in for lawful gold and silver. Well,
actually,
they took...
Can I interrupt for a second? I did find a bill, a $10 bill that stated that you can request to have gold, that redeemed as gold. That was in...
Right.
Yeah.
Right, and that's you're right. You can request it, but getting it is going to be a whole new story. So what happened was that the bank had you come in and you signed documents. One of those documents is a note. That note has one signature, not two. One signature on the document is not a contract. That's an authorization form. One person signing something is authorization to execute something. Sticking with that note for a second, you just authorized the Federal Reserve note, or the Federal Reserve Bank, by your authorization to print the face value of that note. If it was $100,000, you signing that note just authorized the Federal Reserve Bank to print $100,000. Now, You handed it to the lender. The lender also had you sign what was called a servicing notice, that the bank was your servicer. That's where the trust is created, because now you are entrusting them to service that which you executed. The bank runs to the Federal Reserve Bank and says, I got money. Here's $100,000. Print it for me. Oh, by the way, I'm also the trustee. So the Federal Reserve Bank gives it right back to the bank. The bank then transfers that money over to whoever you're doing business with so that you can buy the house or car. However, what you didn't know is that there was a trust being created and that you authorized the creation of the money. So what the bank did was just took your $100,000, put it in their pocket. They said that they were your representative, and then they went and paid off whatever it was you wanted to buy, and they created a note with it, and now they're going to take that note and put it on the open market and start trading it and make millions of dollars off of it. Did you authorize any of that?
No, I get it.
Did you even know? Did you even know any of that took place?
No. So in hindsight, when they say words can be misleading, so servicer can be the trustee? Is that what you're saying?
That's what they're acting like. They're not supposed to do that, but that's what they're acting like. And in reality, if you want to get really in depth, and I please, if you get lost, I'm sorry, but this is now getting into real tricky SEC stuff. When the bank is the servicer, however, let's call it Bank of America just for conversational pieces. Bank of America becomes the servicer. However, Bank of America trust number 1234567, dated January 1st, 2015, is the mortgage security that note, as well as many other notes, are represented in. So they make now what's called a pool of notes in one, and that's called the mortgage security. Now, technically, the servicer created the trust, which is where the note is represented, which is why they call it, earlier in my conversation, I said they have a beneficial interest in the trust. Well, sure, they have a beneficial interest in the trust. They created it. But they are not owners of that note. It does get kind of fuzzy, and it's done that way by design. They don't want the people figuring this out. If it was easy, we'd have figured this out a long time ago.
Yeah, I get that. I mean, it took me years to figure out what was going on with the whole system, and then, I feel like I had a vested interest in the car. I mean, I've let the car go, and I'm not worried about it, but the fact is that they're still coming after me for money is beyond me. But when I feel like the amount that was already invested in it, and I don't have the property anymore, that's why I'm looking for the solution to this issue that's hand right now. But
right, because they're saying that you basically took $20,000, got a car, you only paid $5,000, and you own $15,000. I mean, that's basically what they're saying, but it's not true, because you didn't take anything from them. Here, let me explain the standing part to this. Maybe this will help explain it a little bit. If you come and borrow $10,000 from me, and then someone else is collecting the payments, how in the world can that someone else sue you in court of law when they were not the true damaged party? How is that possible? It's not. That's the same thing that's going on.
They're suing for the person that they're collecting for.
Right, I understand that, but answer me this question. If the bank can't loan its own money and it can't use its own securities or notes or debentures or evidences of debt for its operations of business, then how can that bank go into a court of law and lawfully say that they were damaged? What were they damaged from? What did they give you that they were damaged from? They are not a damaged party. Therefore, they can't have standing. Affidavit proves every bit of it. You lose. Please show me, Mr. Bank, where you lost one penny. Are you telling me that you loaned me your money? No, you can't do that because that would be a violation of federal law. So if you didn't cough up your money, then how can you be damaged? If you are not damaged, you do not have standing in a court of law.
But they get away with it. I mean, they get away with it all the time. Look how many people
because
get into
people are
foreclosure.
asking, people either sit back and do nothing about it, or they ask the wrong questions, or they don't present the right facts. People go after the note. You know what? Go after the note all you want to. And you know what? You're probably going to be right. Are you going to win? No. Why? Because you didn't stop standing. And I'm with everybody out there. I know the note thing is a big problem. If they don't present the note, they don't have proof of the note. I go deeper than that. Prove standing. You prove that you even have a right to be here. If they can't prove standing, it doesn't matter if that note was sealed in gold. I don't care.
Got it.
All right. Is that good for you, my dear?
Yeah, thank you.
Thank you.
I
Let
hope
us
so.
know how that
Yep.
turns out. Okay.
I hope so. Good luck.
Okay, on the call.
All righty. Next up, we have Central Florida. You've been unmuted. Go ahead, Central Florida. Do you have a question or a comment?
Yes, I do. Thank you, Angela.
You're welcome.
And thank you, Dan, for taking the time.
You're most welcome.
It seems what you're describing is, I take it back to the McFadden speech, but McFadden didn't explain the process of how the distiller signs the note and submits it to the discount window. So it seems that you're describing that I sign the note and the mortgage company or the bank is the vehicle that takes the note to the discount window.
Correct. Absolutely correct.
To accommodate the bankruptcy or the remedy because they've outlawed gold or money.
Correct.
And they're not telling us this.
Right.
And so therefore, you and I should be able to trade or do business the same way, but we don't know how to get to the discount window where the bank does.
We were. And I'll tell you right now, up until 2004, we actually had people going up to the discount window. And when the San Francisco Federal Reserve Bank caught on to what we were doing, every single Federal Reserve Bank overnight stopped instantly. And the rules changed, and the 12 United States Code, I believe it was 922 at the time. I might be wrong with that section, but it did allow other people to go to the Fed window, and it was being done. And once they caught on to what was going on, they zapped that quicker than hell. And I'm sorry, that whole statute just disappeared overnight.
So, well, shouldn't the bank serve as the discount window? I mean, how can everybody go to New York? Shouldn't the bank serve as that purpose?
It should. In common sense thinking, like you and I rational thinking, it should. Yes, you're right.
Okay. That's my comment. That's what so now basically we're stuck going through court and affidavits and everything, when everything should be as simple as going to the discount window, which the bank should be there to serve that purpose.
Right. We should be able to do just like them. I could go up to you and say, here's a note. Since they took all of our money, here you go, sir. Go ahead and take this $100,000 note. Go ahead and cash it. You got the money, and now I get the property. In common sense thinking, yes, that is absolutely what the law did say at one point in time, and I apologize. I can't find it again. It was there, and we were doing it. And I shouldn't say we. There was about 4 people that I know of that did it. I did not participate in that, but I was good friends with people that actually showed me the documentation. And I mean the original sealed documentation. I was floored by it.
So if the IRS sends me an offer, we believe you owe us $1,000. Shouldn't I just be able to sign across it and send it back and say, here you go?
Well, now you're going with more or less the acceptance for value, or the what do they call that? They had closed checks and they had site drafts and bonds and bills of exchanges and stuff like that. Here's the problem with that. In my opinion, and I'm not saying it's wrong. I agree with the concept. However, I believe that morally, it's an injustice to do such a thing, because one fact remains. When you do something like that, you bear the proof or the burden to prove what you're doing. And if you can't prove the existence of the account where that money is held, you're going to lose. Number two, it doesn't stop the problem. The fiscal currency that's currently used right now, our fiat currency, the Federal Reserve, continues to do business as usual using that method. So as far as I'm concerned, legally, you're going to lose until someone can get actual, what I'm going to call absolute fact, not hearsay, not speculation, not a copy of a copy, but I mean gold-sealed government or presidential documents of proof of that account that you are going to use the money from to discharge or clean up or whatever, pay off that bill. You're never going to see a win. You have to have that proof because you carry the burden, because now it's your document and you have to explain it. And if you don't have the proof, you're not going to get it. They'll never let it happen.
So it'd be something to the effect of, thank you, Mr. IRS. Please I accept your offer. Please file it according to 12 U.S.C. 447 or something like that. And then they would go and it would be done with. It should be that simple.
It should be.
Okay.
But I don't think they're ever going to let it be. I mean, you're doing the same thing I'm trying to do. I'm trying to collapse the system. I have no problems with saying that right now, because I think the Federal Reserve is the most evil, corrupt corporation that this entire planet has ever seen. And to shut that monster down is going to be a big hill. It's not going to be easy. And if one person gets away with that, and then 10 people will, and then 100 people, they're going to stop it because they're going to protect their means for life.
So basically you're saying prepare to barter just in case.
I try to live under that system right now. I try my hardest to. I try not to take out any kind of loans or any kind of things like that, because I truly believe I'm the minority here. I think just like the cure for the IRS, April 15th, the entire nation just stop. What are they going to do? They're going to put the whole country in prison for real? Come on, just stop. Nobody pay. Nobody file. That is the people in this country standing up with each other. Same thing with banks. Stop using them. You stop using them, they shut down. If they don't shut down, they're certainly going to come back with lawful ways to do business.
Yeah. Well, you're very well spoken and very well studied, and I appreciate you sharing your knowledge.
Yes,
and
thank you.
And
you are, yeah, you are on the right track, but I fear that it's going to take more than that. So,
thank you, Angela.
Thank you. Thanks for coming on. Anybody else? Press *8 if you have a question. Otherwise, I don't have anybody asking questions at the moment.
Okay, Angela, I'm going to do what
here's one.
Go
here's
ahead.
one.
Go ahead.
All right. Go ahead, Donaldson. You've been unmuted. Donald.
Oh, thank you.
There
Yeah,
you are.
it's me. Yeah, thank you, Donaldson. What I want to do is get rid of $37,000 in back child support debt that I don't think that I mean, they didn't even give it to my kids. They have it sitting back. And, I was going to go in and try and assign, well, after I do some more studies, some roles, but and go with this whole idea that there's, and this trust, if they want to do it like that, and hold them accountable in their terms, correctly.
Well,
what do you think about that?
The trust is absolutely not going to work in this because there was no borrowing of money. And honestly, I don't even know where to begin to talk about this topic because one of the least of my studies is family court. So I really don't even know where to begin. But I know that the affidavit is designed for a trust that created money. This didn't create money. This was an order to pay certain amounts for another living being. There's two human beings involved, and that changes the entire topic right around. And I apologize, I don't have answers. Okay. I kind of slipped that in there. I guess I had some other things on my mind.
But in regards to the trust that was created with the Declaration of Independence, first of all, was there a trust created by that document? And secondly, in the Declaration of Independence, at the end of it, where it states that we mutually pledge our life, our fortune, and our honor to each other, could that be, part of the, it's not really being pulled over our eyes, it's just not being talked about. So it's like a presumption of a trust that's, you know what I mean? It's like it's an implied trust by assent through silence, right?
Our entire political regime is a trust. So every document from its inception are nothing more than minutes from a trust. If you sit back and think about this for a minute, we, the people, are the grantors that granted our beliefs, our political decisions, and our rights to law to a trustee who happens to be our representatives. So I'm not going to argue with you. It is a trust, or at least a document from the very trustees. I hope that just opened a whole brand new broad range of thought in your mind.
You hope it opened up what?
A whole new broad thought of trust.
Absolutely.
There's a great book, and this book was written by Stephen Pevar, P-E-V-A-R. Stephen Pevar is the lead attorney for the ACLU in New York, who he's a lead counsel for all Indian affairs. This gentleman wrote a book, and this book describes trust law. And I'm telling you, if anyone wants to know about trust law as a country, as a society of people, this book will enlighten you. I got that book, and it was referred to me from a very, very dear friend of mine in New York who has some very high-powered attorneys. I got that book, and I couldn't close it.
Would you mind
what's it called again?
Repeating the name of that book?
Yeah.
It was Stephen Pevar, and it's rights. As a matter of fact, I got the book. Hold on a second. I'll go in here and grab it real quick. This is an awesome book. It's actually the first book that I got regarding
trust. Is it P-E-V-A-R?
Yes, Stephen Pevar. And
I'm in Chinatown, by the way.
Oh, you
I'm
are?
in a
Okay.
again in Cafe. It's a bunch of Chinese people.
Yeah, there's a lot of noise in the background.
I'm gonna mute myself here.
Okay. Yeah,
called,
mute yourself.
It's called The Rights of Indians and Tribes by Stephen Pevar, and Stephen is spelled with a P-H. That's S-T-E-P-H-E-N-L, middle initial, and Pevar is P-E-V-A-R. And I'm telling you right now, this book gave me a great foundation on trust. And it gave me a good foundation so that I went and started looking and started reading in Bogart's trust law, and everything in there now made absolute sense to me.
Hey, thanks for that. I will look up that doc. I've already got it pulled up, and I'm going to try to find something in PDF.
Yep.
Thanks a lot.
Thank
You bet.
you.
Thank you.
I just, yeah, that idea about the trust with the initial independence declaration, is crucial because, a lot of people who claim to be U.S. citizens don't really even think about the original pledge. So I hate to keep harping on that point, but yeah, it is a broad perspective when it comes to thinking of trust. So I hope people are paying attention.
And you're scratching on the surface of something that I haven't talked about. It is ongoing right now, and it is the original, and I mean the organic habeas corpus as written from the French king, and it is nothing like what's being presented nowadays in American law. And when it's read and understood, we have trial bases going on right now where we very well may have a solution. I'm not going to promise anything, but it looks pretty promising that one habeas corpus can just take people right out of the entire United States jurisdiction with one form. It's in the mix right now. Like I said, there's a lot of things that are going on, and I do stay busy. And Angela, I was actually going to tell every call I get on of yours, everyone keeps saying, "How'd you get rid of your tax? How'd you get rid of your tax? How'd you get rid of your tax?" I don't want to talk about this, but everyone keeps asking. So here it goes. I was imprisoned for 5 years by the federal government for willful failure to file, I shouldn't say that, for tax evasion and also bankruptcy fraud. And the entire underlying premise was that I did not pay income tax from my business. I never owned a business. They knew it. They knew who did own the business. I went and I spoke for these people, but I did not own it, and they knew it. Well, I couldn't get to the people that did own it because they were out of the country, nor could the government get to them to prosecute them. So they killed two birds with one stone. They nail me because I'm out there publicly speaking, embarrassing the Federal Reserve. So I didn't have a tax program. I didn't have tax scams. That wasn't even me. I was commercial, corporate, UCC law, and also banking. So I go to prison. I'm released, and one of my stipulations was that I had to file tax returns. So my little brain says, fine, you guys want tax returns, and you guys claim that I own a business? Fine, chew on these. So they got tax returns, and everything was clearly signed under prejudice. Everything that I put on there, under threat, duress, and coercion, it's against my will. I don't agree with this. You want it? Here you go. I claim that I own that business, and I wrote everything off. Everything. So all the alleged income that they said that I made, I took every business advantage I could, and I zeroed it right out. Both the state of Michigan and the United States federal government have zeroed out my tax liabilities for the years that I went to prison for. And if they wanted to come back and say they were wrong, then I would have instantly had the right to go back and sue them for false imprisonment. Because they'd have to come back and say, you can't take the tax breaks. Really? The court said that I own the business. So it was a way for me to take advantage of what they did to me to zero out those accounts. And I did. Is it right? No. Is it coming out? Yes. If there was any kind of recourse from them to come at me, they would have to say that I didn't own that business, and that would have opened up Pandora's box to allow me to go back using that to put both the IRS agents as well as the prosecutor in prison for false imprisonment. And they're probably still chewing on that right now, and they know what I'm up to. So I'm playing a game of chess with them. And this book, and once I'm off paper, I'm suing it anyways because they never had jurisdiction. So I hope that quiets everybody down.
I hope so too. All right, next up, Anna 88 Bell. Go ahead, do you have a question?
Hey, I was looking at this affidavit that you have on Angela's site. Is this the affidavit that you're talking about?
Yeah.
Steps 1 through
yeah.
26?
Say that again. What?
That's steps 1 through 26 is the affidavit.
I don't know what he's talking about. 1 through
Steps
26.
steps 1 through 26.
Yeah. That's what's listed on this affidavit. That's on your site.
Let me go look.
Yeah, I'm sorry, Angela. I don't visit the site, so I don't know what he's saying.
Okay, can you hear me now?
Yeah, barely.
Go ahead, Verizon.
We're looking at steps 1 through 26 on this affidavit. I'm just checking to see if it's the correct affidavit.
Hey, hold on, I'm going there now. Let me.
It's the affidavit. Let's see, where were you? Let me get down to one of the steps.
Getting a lot of feedback.
What's the name of the document? Up on the very top, the caption. What does it say on the very top?
I'll have to go back and look. Hold it.
Affidavit of trust.
Affidavit. Wait a minute. Affidavit of fact. Wait a minute. So up the top. Where did I find it at?
Well, it's on the web page. It's the first thing under Dan's picture on the left.
Yeah, affidavit of trust.
Okay,
yep.
I'm opening
That's
it.
I believe that's.
I didn't put any steps in there.
It's a five-page document.
Wait a minute. Let me go get the document.
Not steps. Those are items. You know.
Or items, rather.
Yeah.
Yeah. Items on the affidavit.
26 on the left.
I'm looking at.
An affidavit is just a statement of fact.
Yeah, well,
you send it certified to the director so that you try to get them to rebut it. If they don't, then it becomes a stated fact that's been presented to the opposing party, supposedly giving that party no choice to rebut it later.
Well, what we're looking at here, item 2 is original lender's name. Hereafter, lender is engaged in the business of taking deposits, making loans. That's a step 2, and it's
not. They're not steps. That's just
items.
One, right?
Yeah. Items. Okay. I assume this is the thing you're talking about.
Yeah, and what I encourage you to do is go through that and add or delete things as stated facts. You go through the current events as to what transpired in your issue, because you can't have a cookie cutter form that you just print, sign, and file. Second reason, yep.
Yeah, I fully understand it. For the people that don't understand it, it's good information. The other problem is that this case was gone 7 years ago. That the credit card people came against me and ended up with a bunch of money out of my bank account. You're saying that I could redo this and do it in such a way that I could go back after the people that came after me and show they had no legitimate right to come after me.
Here's my reasoning behind that, and I have yet to be proven wrong. But again, nobody has brought me back, hey, I filed it, it worked, or I filed it and it didn't work. However, I again stress standing, because there's a court case that's current to this day, and it's 1998, and it's Steel Corporation versus Citizens for a Better Environment, 1998 United States Supreme Court. That court case not only disclosed and made it crystal clear how standing and jurisdiction works and operates in this country in all courts, but it also gave the order of operation. And the order of operation that it talked about, it did talk about different kinds of jurisdiction too. You know, you got in personam jurisdiction, and it's a great case. If you go and read the case, it'll take you a little bit, but it's an awesome, awesome case where they give standing, jurisdiction, and then the merits. Merits are just the facts of a case. For those who don't know, I'm not challenging you, sir. I kind of have a feeling you know this.
Well, we're all learning as we go.
Okay. Well, what it is that the court has to take a particular step-by-step procedure. In other words, the court came out and said that jurisdiction is the first step. It has to be proven. Once jurisdiction of the court is proven, then the court must move to standing of the parties. After jurisdiction and standing have been proven, then they can go to the merits of the case.
Yep.
I'm gonna now cite a different court case. This is taking it up to 2002, United States versus Cotton, U.S. versus Cotton, Cotton. U.S. versus Cotton basically come out and said, Steele had it right. The Supreme Court has heard this, and we're done talking about it. That's what I'm saying. That now becomes what they call concrete law in our system. It's done. It's heard. Res judicata. It's over.
Yep.
So Steele was right. So with that being said, if you go back to standing of a party and they can't prove standing, it strips the court of jurisdiction. All these courts, all these prosecutors, all these attorneys out there, they want to go right to the merits of the case. Well, he had a loan. Whoa. Slow down a second. Slow down. We haven't established jurisdiction and standing. U.S. versus Cotton amplified that Steele Corporation had it right. I am here challenging jurisdiction based on this company's lack of standing. Here's the affidavit to prove it.
Yep.
What did you take out? Did you take out a loan? You're going to the merits. Your Honor, you're in violation of the Supreme Court. We must establish jurisdiction and standing first.
Yep.
Well, did you get a loan? You have to abide by the Supreme Court. Stay on it. They're going to fight you. They're going to try everything they can to deceive you and get you to talk about the merits. Stick on standing. Don't leave it.
Very good. Thank you.
Mm-hmm.
I got her.
Okay,
Thank you, sir.
thank you. Next up is Arizona again. Go ahead, Arizona.
Yes, I have a question for you about that case you mentioned about Steele Corp. I didn't get all the details on that case.
That's
The 1998 case?
Yep, 1998 in the United States Supreme Court. It was Steele Corporation versus Citizens for a Better Environment.
I want to take a look at that. Better Environment. Okay. And you said the one that's solidified it was USA versus Cotton. What's the date on that?
2002.
Okay. Thank you.
Yep, you're welcome.
Bye.
Very vital cases right there because you can hold a court liable right there. And if the court proceeds against you, well, I want to talk about this for a minute because this is absolutely crucial, and so many people get it wrong. Before you go on, does that apply to any case regarding every case, civil, criminal, you name it. There has to be jurisdiction. You know, go read that Steele Corporation versus Citizens because they go through and they talk about venue, standing, in personam jurisdiction, subject matter jurisdiction. They describe it all. It's kind of a lengthy case, but please take 20 minutes and read it. Then take another 20 minutes and read it again. And then take another 20 minutes until it's ingrained in your brain because that case is absolutely paramount with any judicial encounter.
That's what I'm planning on doing. But before you get into that, what is your take on the age of majority? Because I've heard people say that unless you claim age of majority, then they really can't listen to you because you're still an infant. Have you heard about that?
This is the first time I've even heard about this. It sounds to me as though people are out there grabbing at straws trying to find a way to sidestep an issue when the simple fact of the matter is I'm going to call a spade a spade. You have a right to be here, yes or no. If not, I'm out of here. And if you want to judge against me, this is very, very crucial. So many people mess up on appeals. Very simple, folks. And Angela, if you want to, I can send you a blank appellate brief so that people can actually see how to properly lay out an appellate brief, fill in your case blanks, and file it, and you'll get their attention. When
That would
people
be
lose
great.
a case,
I'll put it up on the site.
What is your site, Angela?
MyPrivateAudio.com.
Okay. Thank you.
And what you do is go to the guest speakers page, and they're all alphabetized. Go to D. Dan Benham and click on his name, and it'll open up his section on our website. There's a lot of stuff there. There's still more stuff I have to put on there, but
actually, it's probably better that you take a bunch of stuff down because
you make a list of what I should take down.
I'll have to find a minute and get there. Yeah.
Huh?
Well, it's a lot of it's just outdated is all, and
all right.
Revamped or revised. But anyways, I do want to talk about appeals for a minute, and this is something that we really haven't talked a whole lot about, but hopefully I can help some people out here. Because a lot of times you get judgments against you or you lose in court, and people don't do it right. So anyways, what an appeal is, and I want to start with that because so many people file an appeal and then they make the same arguments they made in court. That's absolutely wrong. It's already been heard, and you're going to get ruled against instantly. The lower court heard this. You didn't present an arguable controversy to the appeal. For example, you go into a court, challenge the mortgage, and the judge just railroads you, doesn't let you listen. You file an affidavit. He says, whatever, I'm ruling with the bank. I don't care about standing. I'm just going to move forward. Okay? Your appeal should be nothing other than, did the court err by avoiding the standing challenge? See Steel Corporation versus Citizens for a Better Environment. See also U.S. versus Cotton. Here's the transcripts. I mentioned it. I had a certified affidavit filed with the opposing party proving that there was no standing, and the court ignored it even after the document was filed and after I raised it. Then, excuse my language, shut the hell up. 3 pages, 4 pages, that's it. Did the court err by avoiding my standing challenge? The court appeals now has a controversy that appeared in court, and you're not challenging the facts no more. That's over. You're done with it. You tried, you lost. Now you have to go to the appellate court and tell the appellate court to please listen to my argument. I'm arguing that the court was wrong by avoiding standing. That's it. Don't go into the argument about lawful money or the trust or anything else. It's already on the record. Simply go to that higher court and say, did the court err by refusing to address standing after properly challenged? If the court didn't address it, the appellate court has to go back and reverse. And they're not going to reverse the decision. They're going to reverse it with instructions for that court to discuss standing. The appellate court will not tell you if they have standing. They're just going to send it back to that lower court and say you have to address standing. And I guarantee if you take that appeal, when you get to the next higher court, if the appellate court doesn't do it, bring the same issue up. Did the lower court argue or did the error by not addressing my proper standing challenge? Guess where this is going to end up? Right back in the Supreme Court, and the Supreme Court is going to say, you guys have got to address this. We've said it in steel, we've said it in cotton, and the lower courts are still not abiding by it. That's how the appellate process works. You don't relitigate the argument. You go and ask the higher court to correct an error from the lower court and say no more. Don't bring anything else in there. I'll be open for questions on that one, too, because there probably will be a couple.
All righty. Anybody have a question? Press *8. Donaldson's been waiting. Go ahead, Donaldson. You have to unmute yourself. I unmuted you on this
Yep.
end.
Thank
There
you. Thank you.
Okay.
Can you repeat the last thing you just said?
About opening up for questions, or the last part?
Yeah,
of the
just before that. Yeah.
Okay. Well, if you appeal a case and the appellate court decides to not hear it, or they rule against you, I should say, then you're going to take it to the next higher court. And then it's going to go to the next higher court, to the next higher court, and finally you're going to be right back in the Supreme Court, where the Supreme Court repeatedly now has said, we have addressed this. This is the way our courts work. You will prove standing. You will prove jurisdiction. And if the lower courts don't do that, you just keep. Here's my theory of the Supreme Court. You base your arguments on what the Supreme Court has already determined. In case you get there, the Supreme Court's going to say, we've heard this. What's wrong with you courts? I've actually, one gentleman,
Right.
Matter of fact, Angela, I believe that this gentleman was from Kentucky or something. He had an issue, and I referred him to a friend of mine out in West Virginia. He's a lawyer. He trains law firms out in West Virginia. I learned this from this guy. This guy goes out and he sues governments, and he also trains law firms on how to sue governments. Great individual, extremely brilliant man. And he actually said that he took a decision from the Supreme Court, copied it to his brief, edited out names, put his client's names in there, and filed it. Filed it in, and the court ruled against him, and he said, thank you for rendering a decision against the Supreme Court. This is going to be fun. And the judge said, excuse me, and he handed him the case from the Supreme Court and said, read it. It's word for word. And the judge immediately reversed his position on the spot.
Mm-hmm. That's interesting because the reason why I even wanted to mention something about what you had said was because it's important to note that in the appeals and even in the trial court, the communicating should mostly be done through writings, and you shouldn't have to say anything, and you can put it quite succinctly. Yep. And for oral argument, I mean, hearing you say, just for the listeners, hearing you say that you want to go in there and just keep it simple and say this and say that. Well, really, right. You want to say it in writing, peeps, my folks. Right. And then if they ask you anything, right, it's my understanding, correct me if I'm wrong, that to just have the judge refer back to the paperwork again.
My affidavit speaks for itself.
Right.
Bill Clinton used that perfectly. My affidavit spoke for itself. What does this mean? I stand on my affidavit. Bill Clinton taught everybody a lesson on that one. Absolutely. You were absolutely correct.
Cool, man. So, yeah, man, thank you for letting me mention that. And also, I had a question about the tax stuff, if you want to shift gears for a quick sec.
As long as I don't encroach myself on anything, you're fine. But, again, that's getting into gray territory, so.
Okay. Well, out here, they have 17020. I'm in California. Of the Revenue and Taxation Code, and it says the definition of trade or business includes the performance of the functions of a public office. And so when I was looking on the back of the form, the tax form, they said that U.S. person includes but is not limited to yada, yada, yada. Now, what I realized from reading that was that they were using the word includes in the legal definition for trade or business in its limited sense. And so do you think that would be a reasonable argument, that the work that I am performing is actually not the performance of the functions of a public office, and I could utilize that?
There's a book written right now by a dear friend of mine who wrote this book, and it's called Cracking the Code. And I say a dear friend of mine because he and I did do a lot of intermingling before, and then we both actually ended up going to prison, him not for taxation, but for the writing of this book called Cracking the Code. And we actually got to spend a little bit of time in Milan Federal Penitentiary together. But anyways, this book goes through and dissects that very topic that you're talking about. And with that being said, I believe it's Section 3120 of the United States Code. You take that code and go back to the he wrote the United States Code. And for me, I'm a Bubba said person. Just because Bubba said it don't mean it's true. I'm going to read it myself. And I encourage everybody on this call to listen to what I just said. What Dan Benham is saying is Bubba said. Go read this stuff for yourself to find out for sure. Two things are going to happen. One, you're going to know it for sure because you've seen it with your own two eyeballs. And number two, more importantly, you're going to know that it does exist and that it's not false. That being said, I know that the United States Code is just a restatement of the law. It is not the law. All you legal gurus out there, hear me. Go to any lawyer and you ask them how many statutes there are. I guarantee you that 9 out of 10 of them, if not more, will say 50, and they're dead wrong. The statutes at large are the law. The United States Code is mere prima facie law because it's written by a group of lawyers known as the Law Revision Council of the House of Representatives that take the statutes at large and restate them and put them in certain topics of the United States Code that's easy for citizens to understand. However, the Law Revision Council themselves on their own webpage admit that if there's any discrepancy whatsoever between the United States Code and the original statutes at large, the statutes at large prevail. Not only do they admit it, but every single court, every single jurisdiction in this country unanimously agree that the statutes at large prevail over the United States Code. That being said, I went to the statutes at large to read exactly on your topic that you're talking about. And it's amazing what you will read inside of those statutes. You are correct in what you're saying. Getting them to acknowledge it is different.
Thank you.
But they do. They say exactly what you're saying. However, what I did is I went to the Library of Congress and I got a certified copy of that original statute right straight from them, stamped with their original seal. And I did that with a bunch of sections of law. And I filed it, and I was under arrest faster than you can shake a stick at. I was gagged. I was not allowed to present anything. Not one document was filed on my behalf. They rejected my pleadings. They wouldn't even let it be put on the record. I do have a court case number if anyone wants to go and see for themselves that they rejected over 25 of my filings. Would not let me speak. The judge wouldn't even let me answer questions.
I believe it.
So, with what you're saying, yes, you're right. But I believe that the book, Cracking the Code by Pete Hendrickson, will give you a great insight on what you're just talking about.
I will download it into PDF and upload it to audio to listen to it.
Mm-hmm.
Thank you.
Yep.
Excellent answer, by the way. Perfect.
Thank you.
Yes, sir.
All right, is that it? Anybody else? Press *8 or type it into the chat. Thank you, Donaldson.
Yes, and I apologize for the vagueness on the answer with taxation, but there is a specific provision in my alleged probation that I'm not allowed to give advice on tax matters. So I really have to sidestep a lot of those questions.
They actually don't have statutes at large here in the law library at off of 8th Street in San Francisco.
Thomas.loc.gov. Matter of fact, I paid $3,700 for a complete set from the Library of Congress. You can contact them, maybe get 20 or 30 buddies together, everybody pitch in $100. You can buy a CD set of every statute from day one this country was founded.
Interesting. And are those statutes written correctly?
Oh, it is actually just photocopies of what Congress actually wrote. Yes, it is the actual copies of the actual statutes.
Then let me add this for the listeners who care about the correctness issues. Well, how do you? And also maybe you can chime in on this. What if let's say there's some statutes that we don't necessarily chime in with? Can we? And they're being used against us? Okay, statutes at large, and then we perhaps have a knowledge of correct sentence structure. I mean, contractually speaking, if there's no trust, then we have the freedom as man to contract to the terms, and then we could basically challenge correctness on that, even of a statute at large. Am I right?
I wouldn't say you're wrong, but I've never heard it tried. But to amplify your adamantcy on the statutes at large, one of the statutes that we actually dissected, if I am not mistaken, it was 12 Stat 479. I would have to revisit that to check to make sure. But basically, it was one of the original tax statutes. And the tax statute said that any citizen abroad or any person here was to be charged a tax or something of that language. Mm-hmm. Well, that drew up a very, very alarming question in our minds. What is the difference between a citizen and a person? Mm-hmm. So we wrote the Law Revision Council and asked them specifically regarding this statute, what is the difference between a person and a citizen? Because if everybody was taxed, you would have just said everyone's taxed. You wouldn't have differentiated a person and citizen. And they wrote back and told us point blank that the original congressional intent was aliens. The word person was replaced or did replace the word alien. So the original statute, which we still to this day can't find for some mysterious reason, said that any citizen abroad, overseas, or any alien here in the States shall be taxed.
That's interesting because, yeah, you're right. Citizen wouldn't have nothing to do with that.
Correct.
Spot on. Good points, man.
Mm-hmm.
You've got me over here. I'm just stimulated. I've got my law dictionary open and everything. It's fantastic.
Okay, can we move on?
Mm-hmm.
Yes.
Okay, thank you. Next up, we have Alabama. Go ahead, Alabama. You've been unmuted.
Hey, hi, Angela, Dan. Good to hear you.
Sweet home, Alabama. How you doing tonight?
I'm doing tremendous. Hey, there is a website, I believe it's constitution.org, and they have a section that has the entire, or at least up until 2013, PDFs of the entire statutes at large.
Mm-hmm.
And they have it broke down in one section where they have all the tax stuff in statutes for, the volumes that specifically deal with taxes. Now, I downloaded everything on there. It took several days, and it was, when I did this, it was only up to about 2010, and it was over 10 gigs, and that's a lot of just text documents.
Yep.
But on a now I want to get in on a post foreclosure. You can still, even after you've done your affidavit, you could still go back in with and challenge the standing of jurisdiction.
Yes. Jurisdiction is never forfeited.
What would be the proper, how would one, if you were in a similar situation, how would you or anybody, how would someone go about that?
Well, if it were me, and again, it's just my personal opinion, what I would do is I would file a motion to vacate based upon lack of standing and use the affidavit as evidence.
Okay. That's exactly what I was hoping to hear, something short and sweet.
Yep.
The less, a lot of times, a lot of people don't realize less is actually more.
Oh, it is. It is. I have so many times seen and heard, because I do have several friends that are lawyers, and actually I'm going to try to keep this as quiet as I can. Several do actually contact me to do research on a pro bono basis. I do not do it for hire for anyone listening that wants to and try to incriminate me. But what happens is that there are so many times where people file 500-page briefs, and the judges, they don't even read it. they're like, my God, I'm not going to read this. I'm just going to go read the most recent, authoritative court case and go based on it, which two things are wrong with that decision of the court. First and foremost, people have to understand the order of authority in the judicial system. People want to cite court cases all the time. That's fine, but I want to tell you right now that court cases have the least amount of weight in a court of law. Least. They're basically irrelevant. Unless it came from the Supreme Court and it is pinpoint accurate on an issue that you're debating, use it as a reference only. The order of authority in this country is this. The United States Constitution is first. Second is the statutes at large, which do decipher that Constitution. Then they go to court cases. So
wouldn't the Declaration be in there also?
Well, I was just going to talk to you a little bit about, you were talking about the statutes at large. Well, I have another book here that a lot of people don't even know exists. And this book is so empowering. It is called the United States Constitution, annotated with the Federalist Papers. It's written by Mary E. Webster, and this goes through and talks about the constitutional sections, dissected section by section, and then it also then cites the Federalist Papers that the founders used to create that constitutional section. So it annotates and explains why that section is written the way it is and what the founders actually said when they went to draft it. That's why they drafted it that way. Very enlightening. Now, you just mentioned something about using Declaration of Independence. I don't do that. The reason I don't do that is because most judges don't care. And unless it is an issue that is concerning actual independence of a person, I would refrain from that. What I would do myself personally is I would mention the constitutional section, which was founded upon these Federalist sections. Our founding fathers said this, and then they passed this constitutional provision, which was then passed on to this statute, which was then amplified and decided in this Supreme Court case. It's what I call transparency in writing court documents. When you go to say something, I'm sorry, go ahead.
I believe the Declaration is in the Volume 1 of the Statutes at Large.
Mm-hmm. It very well could be.
Anyhow, I'm sorry to interrupt. Go ahead.
No, but I mean, that's fine, but how does that apply to a mortgage loan?
No, it doesn't. I was just making a comment there.
Right, it would, but in conversational pieces, it would have to be something that had to do with maybe, involuntary servitude or something of that nature where, no, we are deemed free. As far as topics are concerned, what most people deal with, I always just go to original constitutional section, and then I cross-reference it to the Federalist paper, and then cross-reference that to the statute that is relevant, and then the most current Supreme Court case going backwards to the oldest. And that was something I learned in paralegal school, is when you go back to the original, you don't go find the most recent court case. When somebody comes up and says, I have a topic on a health code or whatever it is, go back to the original and then start reading from backwards to current so that you can now see. And the reason we do that is because a lot of court cases decided by the Supreme Court, all they're doing is basing a decision on words within that statute, not whether or not how that statute applies or what topics of discussion that even applies to. If you go back from the original, you're going to understand exactly why it was passed, what reasons it was passed for, and then how it evolved over time. It doesn't necessarily mean that it's a void, but now you'll have a great understanding of that topic in lieu of just citing a current court case that might be talking about just a brief section of that code, not actually talking about what it's meant for.
Very good. Yeah, I've done that on since listening to some of your cases, or talks here. Now, last time we spoke, I mentioned the rescission letter. I know you're against doing the rescission letter, but I just wanted to mention this again, that, I've done further research on this thing, and I hope you might have looked into it a little bit too. But, once you send that rescission letter in, the bank has, and you do it timely within the 3-year limit, the bank has 20 days to respond to that rescission letter, and only 20 days.
Mm-hmm.
And during that 20 days, they're supposed to return all your monthly payments, any down payments you put in.
Mm-hmm.
And if they perform all of those things, then you're obligated to give the money back or give them the home.
Correct.
But if they don't perform all of those things, then you're not obligated to them at all.
Mm-hmm.
And, this was a unanimous decision by the U.S.
Sure.
Supreme Court just recently.
Yep. And I don't argue that point at all. But in applicable terms in my mind, people don't want to leave that house that they have. And second, and most important to me, is that does not correct the problem in this country. I'll tell everybody over and over again, I am in this to correct our nation. I am not in this for self-gain.
I'm 100% with you.
Right.
I'm just specifically speaking about my specific situation on a post foreclosure, and I did the timely rescission letter.
Right.
And now I'm out of the home, and somebody's living there now.
Right.
But I did this rescission letter, and now I got to go back into the original court case and prove that they didn't have standing, because by operation of law, the note and mortgage became void by operation of law. And just by that alone, they didn't have standing or jurisdiction. The court didn't have the jurisdiction.
Okay, but let me ask you this. If you rescinded the contract, how could you go sue for damages to a contract that has been voided? Everybody's been appealed. Everybody's been appeased by the original rescission.
Well, the bank didn't perform, and they stole my home on top of that. Okay. They didn't give back none of the money.
Okay,
they didn't give back any down payments, and then they still took it to court and took my home.
Right. Okay, I hear you. Yep.
Okay, that's where I'm at.
Yep. Big difference there.
All right. So the 20 days, the loan was consummated in mid 2006, and the letter was sent early February of 2008.
Mm-hmm.
So that was within a year and a half. So I was well within my 3-year limit. And the green card return receipt actually says on the green card, rescission letter.
Mm-hmm.
So, and I have all this evidence.
Yep.
So, I'm wanting to use that affidavit with the information on my green card and the letter. And I don't know how to really incorporate them both. Or if I really should.
Actually, based on what I'm hearing, I wouldn't even do that. I would just quite simply go in and say, file a complaint after the affidavit is done. Go ahead and let the affidavit go in, and once, if it is unrebutted, then I would just file a complaint and say, I took out a loan, they confiscated the property, I was damaged by this much, they didn't have a right, here's the affidavit, pay me. Short, sweet, and to the point. Don't even get into the rest of it. If they mention it, deal with it when it happens. If they don't mention it, so be it.
You talk about using affidavit of truth.
Affidavit of trust.
Trust, yes.
Right.
Excuse me, yeah.
Yeah, because it's always going to crack open, because jurisdiction is never waived, ever. And if a party doesn't have standing and that party has already won, then you're going back saying, wait a minute, this party didn't even have standing to be here. Therefore, the court's jurisdiction was void from the beginning. It was lacking, and the judgment against me itself is damages.
Yeah. Yep. Now, you wouldn't even try to go back on that rescission letter then?
I wouldn't even mention it because they didn't honor it. If they took your property, they obviously didn't honor it. So I wouldn't even mention it, because if you go into talking about rescission, it's just going to talk about the contract's null and void. You're going back into merits. Again, stick to standing, period. Don't leave it. Don't talk about anything else. Go to standing. They can't prove it. The court lacks jurisdiction. I'm telling you, people make more issues themselves than what's needed.
Right. All right. I thank you.
Thank you.
You're welcome.
Okay, Donaldson, you had another question?
I'm here.
There you are.
Okay. I know Carl's on the line, so I'm going to go ahead and make my question fast. The underground regulations, California. I've read about them. I'm sure you've probably heard of underground regulations, Daniel, and others. But are the United States codes, the underground regulations that have not been promulgated by Secretary of the State?
Number one, I've never heard of an underground regulation. What I can talk about is the United States Code sections are again created by the Law Revision Council, the House of Representatives, and if you go right straight to their site, House of Representatives, Law Revision Council, they will let you know that only certain sections of the United States Code have been enacted into positive law. Many of them, including the Internal Revenue Service, Title 26, Title 12, Banks and Banking, are not positive law. They themselves admit that they're either not complete or they're not completely accurate with the original statutes. If that's kind of what you're reciting to, then I can answer it that way. Otherwise, I'll have to defer to maybe Carl knows what this. I've never heard of it. I don't know what that is.
Donaldson, you still there?
Yeah, I'm here. Sorry, I'm going to put a link in the chat room so everyone can actually go to the Office of Administrative Law online and check that out. I've got it pulled up here. I just wondered what you thought about it.
Yeah, I'm sorry. This is the first I've even heard of underground.
Yeah, I've never heard of it either.
Yeah, I've never.
Yeah,
heard of
they
it.
have to be. The regulation means every rule, regulation, order, or standard of general application, or the amendment, supplement, blah blah blah. But basically, if a state agency issues or attempts to enforce a rule without following the APA when it is required to, the rule is called an underground regulation.
Okay, that's okay. You're talking about promulgation. Yes, and in fact, under 5 United States Code, there is the Administrative Procedures Act that does require an agency to promulgate per regulation. The council, not the council, the Code of Federal Regulations requires that agency to publish it in the Federal Registry, and if such rule or procedure is not so promulgated through the federal regulations, then no citizen is required to abide by it.
Right, exactly my point. Yeah.
Yeah.
So that's why I was wondering if the United States Code was, since it's prima facie evidence of the law, if that's the same situation. I mean, all these municipalities using underground regulations, all of their statutes, and things of that nature.
Okay.
I mean,
I
and then taking it back to legislative history.
No, because it's the administrative procedure. This is for the administrative agencies, not Congress.
Not Congress.
Right.
Okay.
So Congress writes the statute, then they give that authority off to an agency to promulgate.
Right, but that's for the de jure government. I got you.
Right. So the agencies have to publish their regulations. There's two different ones. You have the United States Code and you have the Code of Federal Regulations. The Code of Federal Regulations are not law. They are actually just procedures for that agency to execute that code.
Okay.
And the APA is an enforcement on the agency to follow certain procedures with those rules that are written under the Code of Federal Regulations.
Okay, I appreciate your time.
Yep.
Okay, thanks. Okay, Carl's got his hand up. Hey, Carl, did you have a question or a comment? Carl?
Yeah, I hear you. Can you hear me all right?
Barely.
Barely hear me. Hang on a second.
Sounds like you're a million miles away in a tunnel.
Oh, does that sound any better? Is that better?
Yeah, that's better.
Okay, yeah, I got an easy couple of questions. You know me.
Okay.
I always got easy questions.
Okay.
I hope you're doing well, Carl.
Yeah. We're doing all right. Well, I'm working hard here. So, just a couple of minutes ago, like you said, video.
What are you doing? I can't. You got to put your mouth on the mouthpiece.
Can you hear it better now?
Yeah.
Okay. Yeah, a couple of minutes ago, you were saying who has to pay taxes?
Who has to pay?
Yeah, you explained to some man. You said, child.
There was. I could probably dig through my files and find it real quick. A partner of mine, I'm going to refrain from saying his name because I don't have his authority to say anything, but he did the research on one of the statutes, and for the life of me, I'm believing that it's 12 Stat 479. And that original statute basically, and I'm going to paraphrase here, it's not going to be verbatim, but it basically said that any citizen abroad or any person here is hereinafter, obligated to pay a tax. And it goes into, what specific taxes and blah, blah, blah. Well, that distinction between a person and a citizen caused him to write to the Congressional Research Committee and ask them what the difference was, because obviously not everyone has to pay, only citizens that are abroad and persons here, so it pales the question of what exactly is a citizen. And they wrote him back and told him that the word person replaced aliens, as in aliens from foreign countries. So if an alien from a foreign country comes over here to live, they have to pay a tax, where it doesn't say citizens and aliens, it just says person. Well, if the word person was an alien, then that clearly identifies that aliens that come over here have to pay the income tax, where citizens only have to pay it if they're abroad. And that goes into, I'm quite sure you're familiar with, the the lien levy and garnishment section of the Internal Revenue Code, which only applies to civil servants and so on, and as well as aliens that are here. And it's kind of interesting how all that just kind of intertwines even current day.
Okay. Yeah, like I said, again, very simple question. I mean, if you go back...
God, we're hearing a bunch of humming sound in the background, Carl.
Yeah, if you go and is it still humming in the background?
No, but it's very tinny.
Okay. Well, like I said, it was a very simple question. I was just asking if you go back and listen to the recording, I don't know, about a half an hour ago, all I know he was saying something about all persons and all citizens and all aliens shall, pay whatever taxes, whatever he was saying about.
Yeah,
First of all,
I'm trying to pull up that.
Yeah, whatever you said like a half an hour ago, something with the word shall in it. Like I don't know what you do for a living. I don't know. I mean, I don't know if you're a mechanic, a plumber. I don't know what you do for a living. What do you do for? What's your occupational trade? What do you actually do for a living?
Who, me? Oh, I work at an auto dealer.
Oh, okay. I'm just wondering because everybody who knows, who even these state troopers. When I got talked to a young state trooper about 22, 23 years old. The other day,
I'm sorry, Carl. I can barely hear you. I'm only making out parts of what you're saying.
Yeah, like I said, I was talking to a state trooper not too long ago, a young kid, and he said registration on this vehicle has expired. I said, that's nice. I said, it's my sister's vehicle, and I shall let her know. And I said to him, she will re-register this, sometime in the future. And he said, well, I shall return. So then when he gave me the citation, I said, you do understand what the word shall means? He said, yes. We were taught that at the state troopers, like the police academy. And shall means sometime in the future, but it has no force and effect at this time. So when you folks keep saying that you're reading these codes, you're saying all persons and all citizens and all aliens shall, it doesn't mean now. It has absolutely nothing to do with the present.
Interesting point.
Well, it's not an interesting point because, like I said, even the young state trooper knew what it meant. He said, we're taught at the police academy that we have absolutely no jurisdiction over you people. I said, then why do you do what you do? He said, because, that's what they order us to do. He said, this is what we do.
Yep.
So, like I said, it's very simple. All these people, all these legislators, they all understand about this word shall. And if you look at every single code book, it's like all persons shall and all citizens shall and all like I asked you a very simple question, and this is what would drive me totally nuts. If somebody like you or an IRS agent or a judge or somebody said this to me, did you call me citizen, or did you call me person, or did you call me defendant, or did you call me plaintiff, did you call me judge, did you call me prosecutor, did you call me this? Yeah. Do you know you called me a what? Oh, a defendant has to pay. Okay, a citizen has to pay. An alien has to pay. That's a what? It's not a who. Okay?
Mm-hmm.
You guys are missing the super simple. Are you saying all citizens must pay? All persons must pay? Yeah. Yep. Okay. That's a what? It's not a who.
Taxpayer has to pay.
What's that?
Anybody.
A taxpayer has to pay.
Okay, that's a what? That's a what?
That's
do I look like a what to you, or do I look like a who?
You look like a who to me.
Yeah,
Ooh.
I'm not a what.
All right. So what what else?
Okay, that's one thing. Another thing is, well, first, the first thing I always ask everybody is, first of all, when you guys use these rulings like Rock Class did, the court tells you we couldn't possibly care less what your interpretation of the United States Supreme Court rulings are. We couldn't care less what your interpretation of precedents or case law or the code. We couldn't care less.
Yep.
So why bother using it if they're telling you they don't care what your interpretation is? You have no certification. You're not a member of the legal society. Why would we care to listen to what you have to say? Okay, and like I said, you can say that's rhetorical. You don't have to answer that. And then the very simple thing that happened today. Did anybody read the ruling today about the Affordable Care Act? Did anybody read about the Obamacare ruling today?
No, I heard about it, but I didn't read it. No.
Okay, well, all these citations and all these public laws that Congress is creating, the judges ruled 6-3, except for obviously, Scalia, the number one guy, love him to death. And Thomas, the guy who hangs alongside him, which is great. There's a 6-3 ruling. And the Scalia and Thomas obviously did it right, just like I would say. When you give your word, when you say this is your word, you live and die by that word. Whether you wanted to say it at that time or not, or whether you were in error at the time, too bad. You etched it in stone, you live and die by your word. Well, they agreed. Well, the other 6 justices said, especially Roberts, he wrote the opinion for the court, and he said, well, even though the statute might have used these words and maybe this phrase they might have used, we believe that that's not what they meant to say. We believe, that they really meant to say no. Even though here it says yes, we really believe it means no. So, we're going to interpret that the words that they used in this Affordable Care Act are not correct, and these are the words that they should have used, and these are the words that we believe they meant to use. Right. So no matter what these codes are and these statutes and these public rules, these public laws are, when it gets before a judge, the judge is going to interpret. He's like, well, that's a lovely code. That's a lovely statute. That's a lovely public law. But you know what? Honestly,
I don't really think they meant to say that. I think it means something completely opposite. So where the judge is and justice is. So, we're gonna say that the public law, and the statutes. No, that's not what it means. We're gonna interpret this way instead. So you can master the public law, you can master the statute, you can master the codes. And when you get in front of a judge is going to say like, no, you know what? I don't think that's really what they meant. And you can show them their own definitions, the definitions of the court, the judges will not care less. They did that in a court in England. The man.
That's what they do, Carl. I can't argue with you because that's exactly what they do. We all know that. What I like to do to kind of defend what I'm saying.
What I'm saying is, flooding their courts in the cases that they establish, you're wasting your time. It's just like when I was over in England and the judge allowed the witness, we call the witness, to testify. And obviously the rules are the other side has 30 days to have the witness list and know who's going to be, so they could, examine the witness, make sure he's credible. They could do a background check on the witness. So obviously we didn't have, I wasn't in there for 30 days before the trial, so it was like 22 days or 28 days. So the barrister, the prosecutor, he did a really, he did a wonderful job. He said, well, if you allow the witness to appear, he said, you're in clear violation of Rule 17B. And throughout the history of England, we have a very rigid standard and procedures that we all must abide by. And obviously, clearly, the defendant did not follow proper procedure and proper form. So we're going to have to request of this court to deny the witness to testify. And the judge said overruled. I'm going to allow the witness to testify. And the barrister, I'll call him prosecutor, the prosecutor got extremely, verbal with the judge. He started saying, Your Honor, maybe you don't seem to understand what I just said. In England, we follow certain procedures to the letter of the law. We do not deviate. We do this in extreme, rigid fashion. If you go off the rail and you just decide that, 17B is no longer relevant, well, then what's the next rule you're going to say is no longer relevant? Rule 23, Rule 27, you're just going to start whimsically just deciding what rules apply to you. You do know you're a member of the legal society, Your Honor. You do understand that you have a duty to perform. And you do realize that you must abide by these certain set of rules and conduct. And you must abide by these procedures. And the judge was like, overruled. I'm going to allow them to bring the witness forward. And then the prosecutor went crazy. I mean, he flipped his wig. He started barking at the judge. He was shaking the rail. I mean, he was livid, saying, I have no idea what you're pulling. What in the world is going on in this court? Do you not understand the simple rules? How long have you been on the bench? Do you not understand what you're creating? Do you understand the chaos you're going to start? Do you understand what's going to happen if we don't all abide by the rules? Do you understand what's going to happen to this justice system in England? I mean, the prosecutor was awesome. But these judges are going to just do whatever they damn well want.
Right.
So like I said,
I'm not going to argue that, Carl.
Right.
I'm not arguing that.
Right. So
however,
why allow them to even have a voice in the matter? Why even bring it to the judge? Why even play in their case? Because
real simple. Real simple. If you don't say anything, you lose. You may as well stand up and at least make the judge
that's exactly how you win. You win by saying nothing. Because that proves they never had jurisdiction. As soon as you open your mouth, that proves they had jurisdiction. It's very simple.
So you're telling me if I go into a court of law and the judge starts to talk and I say I'm challenging your jurisdiction, I lost because I said I'm challenging jurisdiction.
Because a judge spoke, a what spoke, not a who. So you're being controlled by whats. So you're a what. When a what talks to you and a what responds, well, what's got jurisdiction over the what? I'm a man, I'm a who, I'm not a what. So when a judge tries to speak to me and says, who's speaking to me? Oh, I'm speaking to you. What's your name, Bob? Bob Smith? No, I'm the judge. Oh, you're a what or a who? The judge is a what. I'm asking who. It's very simple. And you guys are just making this way too freaking complicated.
Okay, and I'm not challenging you. I'm not saying it's not happening, but where's the proof that it works?
Gus got out of jail. Gus got out of felon with possession of firearms 2-3 weeks ago. He was arrested. He was arrested about 3 or 4 weeks ago for possession of felon and possession of a firearm at 3 o'clock in the morning. Gus was on the show last week. You go listen to that call, and we explained in great detail what we did. Another man from West Virginia called up Angela's show last week with proof, saying that he was arrested for domestic violence, fighting with the police officers, assaulting the police officers, and resisting arrest. All the charges were discharged by the prosecutor. The same thing with Gus. Gus didn't put in a motion to dismiss. I told Gus, and I told the other man, you do not make a motion to dismiss. How would you like it if somebody made a motion to dismiss your case? You believe you have a wonderful case. You believe you have a great suit. You want to try that suit on in an open forum. How dare somebody deny you the ability to put on your case and try your suit before the court? I said, so it's nice that the prosecutor dismissed their own case. It's nice that the prosecutor discharged their own case. Don't you dare ask them to dismiss their case. You let them perform. Because when you bring your court in, and you bring your case and your suit, heaven forbid anybody tries to interfere with my ability to put on my suit to the world, to the public, to the forum. I won't allow it. You're going to give me access to that court. I have just as much right to this public courthouse as anybody else, including that man who's acting as a prosecutor. So like I said, it's do I have proof? Go listen to Angela. Angela heard Gus talk about it. He was a felon. He got sentenced to 23 years. They let him out in a year and a half a couple of years ago. He had a gun in the back seat. They went to go collect the van from somebody who wouldn't return the van. The cops stopped him. Him and his buddy got arrested. Gus had his felony in his past, so obviously Gus had to spend a couple of days in jail until he was out. The other man only had a misdemeanor on him. The other man who was the passenger. It's funny. Gus's charges were dropped. The man who's the passenger, who only was charged with a misdemeanor, his charges are still ongoing because that man is a defendant and that man has an attorney. Okay. Gus had me.
Again, Carl, I'm not challenging anything you're saying. However, I come from a place where you can probably appreciate a lot of people say this works, this works, this works, and they say it, but they don't back it up. Hence, that's why I said earlier, Bubba said. If somebody says it, as Bubba said, where can we find the proof?
That's why I emailed the paperwork. I guarantee Angela has the paperwork where the prosecutor moved to no low prosecute Gus's case. Right. And because Gus went to a preliminary hearing to see if it should be sent up to the grand jury for having an indictment, and the judge agreed that it should go to the grand jury. There was enough facts and evidence in the case to move it before the grand jury for an indictment. 2 days later, the prosecutor sent a no low prosecute notice to Gus. Okay, when I sent that paperwork out to dozens of people, and then the same thing with the man from West Virginia. He called up Angela's show, and here's the piece of paper with the prosecutor, the court date, the court cases, the charges against them, and they motioned to dismiss them all.
Right, and I completely agree with what you're saying there, and if Angela's got it, I can communicate with her on getting that information. However, let's transfer this topic now to a civil mortgage crisis somebody's going through. If they say nothing, what's going to happen, Carl? They're going to get stampeded. You're absolutely right, and I'm not challenging that because you're in a criminal section.
No. Angela's muting me. I can't answer you because Angela's muting me.
You're unmuted, Carl. I muted you momentarily so that Dan could respond, and then I would unmute you again.
He wanted me to answer a question, and since I didn't answer it within 3 seconds, he said, see, Carl, it didn't work.
Go ahead, Carl. Please answer.
Okay, what was the question you said again?
Everything you spoke of was for criminal prosecutions, not civil. If somebody is in a civil issue where a bank files foreclosure documents in a court of law, if they say nothing, what's going to happen?
What's going to happen is you move your own case before a court of law. You bring your claim in, and they bring in a complaint.
I can't even hear you, Carl.
What you're going to do is you're going to bring in your claim that by their actions or inactions is causing man harm, and they exist only to cause no harm to man. If they ever cause harm to man, that they are no longer allowed to exist. Their charters to be pulled, and they're supposed to no longer be able to conduct business with man. And you don't believe that? Okay. And what's funny is Angela had some other man call up one night, and he says, oh, that's crazy. And then I said, you know what, fine. Angela muted me. I went home. I called up an hour or two later, and the man apologized. He said there's some hillbilly from Chattanooga. Called up, he said a couple of years ago, you asked him for help on a foreclosure.
He's living in his house still now for the last 2 years, and nobody from the bank is giving him any hard time anymore because I put a couple of simple letters to the bank. And the bank
I never said that you were crazy, Carl. I've never said that to you, and I won't say that, and I don't think you're crazy at all. This call right here is not designed for Dan Benham to come up here and talk. This is an invitation from Angela for open dialogue so that we can try to get our nation back. And if what you got works, hey, I'm all game for it, Carl. I'm not your enemy, brother. I'm here with you.
Yeah,
we're just trying to work. And what I was saying about the statute, by the way, it was 83 Stat 281 to be exact. It specifically says there is now imposed an income tax on any persons here or any citizens abroad. I'm just stating what the statute says.
That's lovely.
If people want to use it, fine. They don't have to use it. But I'm simply stating this is what Congress does.
Okay, what I'm trying to say, Congress is a what? Okay, a citizen or a person is a what? I am not a what. When somebody tries to talk to me, when somebody's trying to communicate with me, I'm going to make sure we're talking man to man. I'm going to make sure it's a who that is speaking to me. It's not a what that is speaking to me. I'm not going to talk to a what. I'm not going to talk to an IRS. IRS is a what. I'm going to talk to a man or a woman, and I'm going to say to that man or woman very clearly what you're claiming, what you're saying, what I owe. Do you believe it's true? And they're going to say, well, I don't believe it's true. Well, then what do you believe? Well, I believe you. Oh, really? And you're going to make yourself liable. You understand the simple law that's been around for thousands of years.
We're losing you.
If you claim, make a claim that I owe you 2 pennies when I only owe you 1 penny. What was that claim? What happened when you did that in open court? It was instant death. You do not claim more than what is due. So, can you prove that this is exactly what I owe? Are you sure? To the penny, to the breath, to the hair. If you watch The Merchant of Venice, you see what they do to the Shylock at the end. Yes, you will get your pound of flesh, but if you're off by 1 hair, 1 breath, 1 drop of blood, one way or the other, you better collect your 1 pound. Because if you take 1 hair, 1 breath more than 1 pound, then you cause harm to man based upon your contract. And you will die immediately. So go ahead, Sherlock, and take your pound of flesh. It's an ancient rule that's been going on for thousands and thousands of years. It has not changed. You guys are making things too complicated. This caveman rule, it's the old-fashioned rule. You can only claim what is due. If you make a claim that's a false claim, that 1 farthing, 1 breath, 1 hair more than is due, it's instant death. We're not going to put up with your nonsense bringing false claims into the public. We're not going to tolerate you wasting the court's valuable.
We're losing you again.
It was very simple. It was a very simple concept for thousands of years. We are not going to tolerate a man or a woman coming before the court with a frivolous claim or complaint. We're not going to tolerate it. And we're going to show you what we do to people who bring false claims and frivolous complaints into the public. We're going to get rid of you. So that's all you have to do. No man who works for the government is ever going to make a claim.
All right,
Carl. They're never going to do it. Okay, well, like I said, I'm just trying to make things super simple because, it's going down. Like I said, thank God they made us the United States Supreme Court ruling today. It said, you know what, honestly, it doesn't matter what the Affordable Care Act says. It doesn't matter. It doesn't matter what the words they use. That's fine. They also created a whole volume of just definitions. It doesn't matter because, you know what, we, the judges, we are so much smarter than the Congress, and we know they really didn't mean to say this. They really meant to say that. They must have just had a bad day. The couple of hundred congressmen, they sometimes they just, they're not paying attention. So, the justices will interpret the law for you. We'll say no means yes and yes means no. We'll do it for you. So what's the purpose of having a Congress? What's the purpose of having public law? If the justices are just going to come and say, you know what? Well, no, you know what? We don't like that law the way it's written, and we're going to interpret it this way instead. So, like I said, just pay attention to kind of stuff like that you're kind of wasting your time. When you're trying to deal with these justices, when you're talking about public law, they're not going to. They go read the opinion. It's a great opinion.
Right. I got it. I'm clear, and I will get with Angela and get some of those documents from her and do some research because I like easy.
Okay. Hey, and off the topic, does anybody know, is Dean running around, or did they hold him over until sentencing? Does anybody know?
I don't know. I haven't heard.
Okay, I was just trying to.
You talking about Dean Clifford?
Yeah, I was just wondering if.
I haven't heard.
Yeah, no sentencing September, but I don't know if he's out. If anybody's had any contact with him.
Oh yeah, he's been out. You were talking with him.
No. He went. He was found guilty.
Oh, when?
Monday or Tuesday. You know, we talked to him last Thursday and
Friday. I didn't know.
Yeah, Friday he had to go to court. Remember? And I said to him, look, when you go to court, you better just do it super simple. You just stop all this nonsense and ask for the who, not the what. Just moving the case. And he kept doing his stuff, obviously. And you know, he was found guilty on all 13, 14, or 16 charges, and the sentencing is supposed to be September 5th. So I don't know if he was released on his own recognizance, which I highly doubt. You know, so it's going to be interesting to see what his sentence is.
Well, I hope it works out for him.
You make an example out of him. I mean, is anybody on the chat board mentioning it?
No, nobody's mentioning anything. Nobody. No, don't see anything about Dean Clifford on the chat. But we got to go, so I'm going to close up shop. Thanks, Carl, for your input. It's always a treat. Some people find it as a treat. Some people find it, I won't say. But
it is, and you know, I would love the opportunity to just sit and talk with Carl, because I think it would be a highly intelligent conversation, and maybe even be able to come up with a lot of very good answers here.
You should hear our last call that we did. It was like 4.5 hours, or 4 hours and 45 minutes, something like that. And Dean Clifford was on, and I forget who else. There were a lot of people on. Gus was on. It was really a good call.
You know, it's very interesting, because what Carl just said is I had and Carl could probably appreciate this. I had a gentleman down in Tampa, Florida, called me up the night before court on a banking issue. He had to be to court next morning. There's no way that, you know, at the time, there's no way I could come up with anything to put on a piece of paper for this gentleman. So I just told him to go into the courtroom, and when the court addressed him, stand up, don't even get in the bar, just stand up in the crowd, look at the judge and say, who are you? And when the judge says who he is, just say, well, you know, do you have a claim against me? No, the prosecutor does. And ask the prosecutor, who are you? I mean, what do you hold against me? What do you got against me? And he said nothing. He said, I don't have anything. I represent the lender. And he said, well, since no one here's got any kind of claims or issues with me, I'm gone. And he left, and everything went mute. And a year later, nothing had been done. So I asked him to just file a motion to dismiss for failure to prosecute, and the whole case went away. Wow.
That's lovely.
Yeah, it's quite an interesting conversation there, Carl. So I don't disagree with you. I don't think you're crazy. I'm wide open, man. I'm so tired of fighting this crap, and I just wish it would just go back to happy.
Yeah. Carl has a way. He keeps it simple, and we love Carl. So anyway, but we love you too, Dan, and I appreciate you coming on. And we've gone our 2 hours. I hope we distracted you enough to get your mind off your friend's passing.
You did. Thank you very much.
I'll say a prayer, and we'll have you on again. I appreciate your time and energy and all your education that you share with us. It's just refreshing. I love it. And everybody else does too. But I look forward to your book coming out. So be sure to let me know when that's available. We'll even post it on the website if you want.
I will do, and I think
for donations, or how are you going to do it? Are you going to sell it for an X amount of dollars on Amazon, or what?
Well, I'm as of right now, I can't operate any kind of business unless I get Mother's approval. So I'll just have to kind of play that by ear.
Okay. Well, however it works out, I'll accommodate. Selling it or moving it. I look forward to getting it myself. All right, everybody. Thank you, Carl, also.
Yep.
And everybody that asked questions, thank you so much. We'll wrap it up, and we're at 2 hours and 19 minutes. It's a nice call. It was good. I appreciate it. Everybody's participation, thank you so much. Everyone on the chat, thank you. And we hopefully I'll have you on again in the not too distant future, my dear Daniel.
Thank you very much, Angela.
Thank you. All right, everybody. Good night. Have a great weekend, and we'll see you next time.
Good night, folks. Thank you.
Thank you. Good night.
Attention Medicaid members, when you choose Silver Summit as your Medicaid provider, you get baby essentials at no cost, same-day appointments, and local support you and your family can count on. Choose Medicaid that's on your side. Visit ChooseSilverSummit.com. Silver Summit Health Plan is a Nevada Medicare and Nevada Checkup Health Plan.